record the meeting so we can upload it. By the way, on the recorded meetings now, I had been downloading them to Dropbox, but it ended up with like 2 gigs of video in there very quickly, and most of the free accounts are only 2 gigs. So I begun the process of uploading them to our YouTube channel, and I'll get everybody a link from that YouTube link rather than store them in Dropbox so that it doesn't bog down everybody's Dropbox. All right, let's see here. All right, y'all should be on my screen pretty much now looking at what I'm looking at. Excuse me. And so if you go into the resources folder now under blank contract documents, you'll see a folder for HW Forms New. Let me turn off your mic.
Oh, I do that.
Let's see here.
Right here. On the top.
I thought it might be Blake. Is that coming out of your?
No, it's coming from down.
Is your volume
Oh,
up?
sorry. Yeah, it's just your volume that we're hearing. Yeah, just turn down your volume on your device. Sorry about that. So you'll see.
Sorry.
That's okay.
Let's get out of
So there's 3 different contracts in here right now. Sorry, we got a little feedback going on in the room.
Okay.
There we go. We have right now just a buy, sell, the listing contract, and a vacant buy and sell. And again, these are the result of that process we kind of went through over the last couple of months, where we began with the MAR form, Michigan Association of Realtors form, and then adapted them to suit kind of everybody's region in terms of the tax proration and fuel proration that you might see in those types of terms, so that it's something that works for everybody's area. I think the important thing about these two to keep in mind, you know, these are the contracts we want you using moving forward. One of the reasons is that they include that technology fee in there for our clients, whether we're representing the buyer or the seller or both. The listing agreement includes the fee for the seller. The buy-sell includes it for the buyer. But also just the terminology is what we feel as the broker to be the most complete and the most clear. I think some of the contracts that were being out there were just not very concise in terms of what happened with the deposit and how that was to be dispersed, when, you know, what the threshold was for inspections, things along those lines. So from a legal standpoint, these are the ones that we'd really like to use for those reasons as well. So let's just go ahead, and I figure we'll just run through each one, and then if you have any questions, chime in, and we'll go from there, okay? So we'll start with the buy-sell agreement. Eventually. I do not have the chat window up just because it's, you know, kind of taking space for everybody. So if you need to chat or something, or somebody sees a chat coming up, just chime in to me, let me know that that's going on. So here's the basic buy-sell agreement. Some changes maybe since the last iteration went out. Everybody seemed to feel that putting the buyer and seller name right here at the top rather than where the signature line is would be easier, especially for lenders and title companies, just to be able to take a look at it and see it right there at the top of page. And the other thought was that if you have it down by the signature area, some sellers or buyers may not complete it if it's down there. They might just sign off and then skip putting their name on there. So we moved an additional line up to the front with that. So property description, like you'll see in most of them, the address, whatever county it is in Michigan, and then a legal description here. Obviously, if you have a lengthy legal, you'll attach that as a separate document, and then tax ID number. Just like the other forms, it includes all fixtures and improvements, including, you know, an option to select boxes for the large appliances. And then there were a couple of contracts that included and or except. One of the other big things I really wanted to get away from is people using the purchase agreements to deal with personal property. Whenever there's personal property outside of the major appliances or anything, we need to be using a personal property bill of sale. And there is a good Word document in resources folder for personal property bill of sale. We have 2 lines here. If somebody wants the refrigerator or washer dryer removed and doesn't want them included and they want to be explicit about that, they could write that in here. Or if they want the curtains removed or whatever, because they're already included up here, you could put under here except, seller to remove all draperies or whatever that might be. So we did include 2 lines here to add if there's a second refrigerator maybe in the garage or something like that that you want to add, you could put that here. But this is not for couches and docks and stuff like that. And we actually added a second line here. This was in the original language, so you saw this already, but that no personal property is included in the sale. Any personal property we purchase shall be done by separate personal property bill of sale between the parties outside this transaction. Again, I think too often other realtors in particular will start adding on personal property in the purchase agreement, and then you got to go back and change it. So we just figured let's just squish that right off the bat. Purchase price, method of payment is very similar to whatever contracts you've used. I don't think there's any major changes there. Same thing with title insurance, pretty standard. Property insurance, property damage, these are all very standard from the original transaction. Closing costs, we did, this is a little different than some of the contracts you might use. So I'm going to just read through it and see if anybody has any question. Seller shall pay all state and county transfer taxes and costs required to convey clear title. Buyer shall pay the cost of recording the deed and or security interest and all mortgage closing costs and fees required in connection with the buyer's loan and issuance of the lender's title policy. Closing agent or title company fee shall be divided equally between buyer and seller unless an additional charge is levied for the closing of a transaction involving a mortgage. Any such fees shall be the responsibility of buyer. The reason we did that is that a lot of the contracts said just that closing fee was split, but more and more title companies have gone to charging a larger fee on the buyer side if there's a mortgage involved. They might only charge $150 to the seller, but if there's a mortgage involved, they would charge a $300 fee on that mortgage side to close that. So we wanted to cover that as we see kind of more and more title companies doing that. So, and then here's the buyer agrees to pay Homewaters LLC administrative fee of $150 at the time of closing. So that's where we plug in the fee that everybody will be stuck with. Any questions on this or thoughts on how we worded all the closing costs? Okay. Real estate taxes, this is another one that was kind of an interesting back and forth because of how different all the taxes are done throughout our areas. We have some municipalities that are in arrears, some that are in advance, some where the...
Chad, I'm sorry. Yeah. I have a problem with where it says for local arrangements for the taxes. I feel that there should be boxes there to check. I mean, maybe someone's from the Detroit area buying it and they do it differently down there, or a seller did not know that we do them based on a calendar year or on a fiscal year, or I think that there should be a little more exactness to the tax proration statement.
We did, and I know that the GRAR contracts that you use had those in there, but the difficulty becomes, like in your area in particular, it was pretty standard. You know what I mean? There weren't too many options, but when you're getting into not only county taxes, but local municipalities and things like that, where you'd have to put so many boxes in here to cover the different taxing authorities and how they were done, and whether it's arrears, whether it's advanced, that it became really convoluted when we tried to do that in a way that suited everybody's area.
Right, and then so per local customs, I mean, is it local where the title company's at, or local where the property is? Or
where the property is.
Okay.
And that's much more standard language in just about every other contract that's there that doesn't have kind of the check boxes or something. And again, a lot of the contracts were written specifically for that local region. And so per local custom speaks to the custom where the property is located. I guess we could clarify that if anybody else feels that would be worth doing. But it seems to be
I just
pretty
think-
accepted legal language.
I think that they still think that there could be a hang up. And if I was a seller, some of my sellers are CPAs and they want to know exactly, I guess at that point I could call the title company and say, how are you prorating these? Basically, you're letting the title company pick how we should prorate our taxes on a purchase agreement. I mean, how they normally do it. I just think that a lot of my sellers would want an exact number. How much am I getting back? Or it'll be somewhat of a surprise the day of closing when they say, oh, well, I didn't know it was done this way. I thought it was done this way. I mean, I've had people say, that they do the numbers before they even send a counteroffer back and say, no, if you're prorating it on a calendar year, that means that I'm actually paying for his taxes or their taxes for the following, these 4 months, and it's a $900 difference or whatever it is. But I've run into it in the past where if they do not know an exact number, it can be somewhat of a surprise.
Okay. Anybody else have thoughts on that?
I don't know that I've ever closed it.
Mine are done on a calendar year.
Yeah.
Yeah,
And it's so simple that way to explain it.
yeah.
Are they proration in advance or arrears? Because some counties pay prior and some pay, in arrears. I mean, they're.
Yeah, and that's the crux of it
Right.
is again, I think Kimberly and Roscommon County, there's an area where county taxes are in advance or in arrears. The township taxes are in advance, and the village are actually somewhere else. That's the problem with going that specific is when you're talking about properties where you've got multiple layers of taxation, Sean, is that there's no way to do it concisely without having this be like a half page with so many options. We had to try to find language in other contracts that was much more concise but still covered all the bases. I think Joni and Jessica, I know you guys also have one where one is in arrears, one's in advance, one uses a calendar year and the other uses a fiscal year. Isn't that right, Jess?
Yes.
Yeah. So that's the thing. You then have to have check boxes for which municipality, whether it's arrears or advance, whether it's calendar year, whether it's fiscal year, and you'd have to do that to cover a county, a township, or a village municipality. So you can see that it eventually would be pretty lengthy and convoluted, especially when most properties aren't that complex,
Chad, can we just use the text feature on Adobe and maybe for each one of us, like sometimes when I know there's something that needs to go on every single contract, I have wrote it in there, like even on the seller's disclosure, I wrote so that it wouldn't be missed, is the water softener purchased, or rented or owned? And
Yeah.
it's come up every time I pull up my seller's disclosure. So could, for mine, with the July taxes are paid in advance and the winter taxes are paid per calendar year in arrears. So could I just type on there, winter taxes in arrears, summer taxes in advance at the end of that tax thing? Since it's per because we always used to type on all of ours, per Roscommon County custom.
Yeah.
Which covered us, but people still never understood it. So if I wrote per Roscommon County custom, winter in arrears, summer in advance.
Yeah, I think under item 11, if you go down to item 11, 2 items later, there's additional prorations there. You
Yep.
could probably clarify under additional items there would be a good spot to do that. That
Okay.
just as a note, in Roscommon County, taxes are prorated here. Same thing for you, Sean. If you wanted to clarify for your clients, you might be able to do that under item 11, just to clarify specifically for your area.
If you go to more, Chad, look like somebody might have said.
Kelly is chatted in, Chad.
Oh, okay.
If you go up to more at the top, that drop down menu, at the top of your screen. Yeah, there you go.
Somebody had a chat up
You
here.
click on more, yeah, looks like it popped up orange.
Oh. Excuse me just a second, guys. I'm pulling up the chat window. And it didn't come up. Looks like Kelly might be trying to chime in, but I'm wondering if she's not able to hear. Can you hear us out there, Kelly?
I'll just read it for you, Chad.
Yeah,
She's
thanks, Preston.
asking,
Appreciate it.
can those specifics be noted just at the end in the other section?
Yeah, there's also text at the end. I think that's the way to go. I mean, again, you know, we put our best effort in this, obviously, to try to get to one contract that specifically spells out everything, so there's no additional, you know, text that needs to be added. But the reality is, it varies so much between our areas that that's pretty tough to do. I think secondly, we all like to kind of do things a little bit differently and convey different things to our buyer clients, our seller clients, just through our own experience. Again, Sean, you've hit, you know, I think a lot of times we have downstate, all their taxes are paid in advance. So to see on a settlement statement that they're paid in arrears can be a surprise to some of those clients. So I guess I've just gotten in the practice of, you know, going through the tax proration with them and getting, you know, helping them understand it. That's a pretty tough thing to do in, you know, a few lines on a contract. So, yeah, I think there are a couple different opportunities under item 11, I think additional items. And then it does seem like there was an extra one at the end for other, perhaps, is that, and I think that's what other conditions down here in 34. It's your opportunity to, you know, if there's things in your specific area that are oddities, or you just feel there should be language included to clarify things, those would be two locations where you can do that, I think. That work for you, Sean?
It just means after every single offer that's given to me, I can call the title company from a different county and say, what are the taxes for this township? And then I can tell my seller that it, you know, they'll be done this way. And then I can tell the buyer, then they'll be done this way. And then they'll agree to it. But I think it's very vague that they do not live around here. Typically people that are buying these properties or selling these properties, and they do not know the local language. I just think it's a question I'll have to answer every time.
Yeah.
Kind of like me with well and septic.
Yeah, I mean, yeah,
Not
and unfortunately, I think
confusing.
that might just be part of it, you know. Again, there are, especially in certain odd areas, like, you know, if I'm selling outside an area that I'm not confident in, or that I don't just know it off the top of my head because I'm not working in there regularly, that's just part of the process.
I mean, I live here and it confuses me, and nearly every seller I have to have call the title company and have them explain to them because it's different. I mean, it's confusing even for the title companies.
Right.
Yeah.
I mean, it truly is. I mean, I've been on conference calls with them and they say, well, they're really paid in advance, but they're really this, and this is the way it is. And I have the title company explain it to the seller. So, and then they said, well, we're going to credit you this, and when the tax bill comes out, if it comes to you, then mail it to him. And if you get the tax bill, then you pay it. But we don't. I mean, it's very confusing. So, okay. I mean, I'll just keep doing it the way I'm doing it and have them call the title company.
Okay. Yeah. It is confusing. And again, when we were going through this process and we had those different conversations, again, Jess and Joni have one that's very odd where they're like part of the taxes are calendar year, part of them's fiscal year. And then again, in Kimberly, in Roscommon County, I think it's a township where a portion of them are in advance and a portion of them are in arrears. And yeah, I have a hell of a time explaining that to people sometimes. And even if you can explain it to them well, them picking it up, is pretty tough to do. So let me see here. So, Joni's in. Give me just 1 second, guys. I want to see if I can invite Jessica in here. For some reason it kicked Jess out. Let's see if we can get her back in here. Okay. Joni, I see your name on the list. Have you joined us now? Well, we'll hop along. Let's see here. Oh, there's Kelly's. Okay, let me get back to the contract here. So we'll see if we can get Jess and Joni in here as we go. I can follow up with a call right after if they can't get back in. Okay, real estate taxes, special assessments. This is another one where it wasn't very clear in some contracts, so we wanted to make it clear and give a specific choice as to whether they're going to be prorated or paid in full to seller at closing. This is another one of those where you might have to add extra language because there's so many different types of assessment. And Damon, some of them are over a 10-year period. Some of them is a lump sum that is coming up. So this is another one of those areas that's pretty tough to get concise enough. So you may have to use the language in item 11 or in other back at the end in order to clarify for your clients. Okay, let's see here. Miscellaneous prorated items, rent, association fees, insurance, municipal water, municipal sewer, heating fuel, which is obviously propane in most cases, as well as interest on any existing land contract, mortgage, or other lien assumed or to be paid by buyer will be prorated to the date of closing. That's pretty standard. We did change, a lot of times there isn't a propane proration built in, so we did add that in there as heating fuel to make sure that that's in, because I know it applies, especially in the more rural areas. Mineral rights is pretty standard. Closing date's pretty standard. Occupancy, I did like to clarify what time occupancy is and so many days after closing. I think the contracts that I've used for so long, it just says how many days, and it's just not specific. So that is a day 24 hours from the time of closing, or when can they actually get in? So we made that change there. Any questions on that in terms of occupancy, especially, or prorated items?
Does the title company typically hold the escrow for occupancy, for rent?
Most of the title companies that I use will hold that escrow. Some won't. And I noticed more and more people are using attorneys as title companies, basically. And they don't seem to want to hold any escrows at all. So we've had a number of closings, trying to think of what area that might be, but I noticed at least one or two of the agents are starting to see some closings where it's actually closed by an attorney's office as the escrow officer, not a title company.
Can we scroll back to financing? I just thought of something with that. Land contract. It doesn't discuss who's going to pay for that contract.
Let's see, percent contract document. I think under closing fees, it talks about any cost to convey, which would be, let's see here, closing costs. Sellers shall pay all state county transfer taxes and costs to convey clear title. Buyer shall pay the cost of recording the deed and or security interest and all mortgage. So this, I would say, is the buyer responsibility, but it is a little bit vague.
It is vague, or it was vague, because that was an issue we ran into, the purchase money mortgage, sure.
Well, where's that, the buyer's loan? I mean, it's saying basically the buyer's responsible for anything relative to the
all right. Yeah.
loan. So
Yep.
I'd say that's buyer's responsibility. Okay.
Hey.
What do we got? Hey, morning, Claire. Okay, let's see here. Where did we go from occupancy down to seller's disclosure? This is standard language from if legally required. Release, this is one where we used as specific a language as we could. So we'll go through this one real specifically. Buyer and seller acknowledge that neither listing broker nor selling broker nor their representatives have made any representations concerning the condition of the property covered by this agreement or marketability of title, and buyer and seller release the listing broker and selling broker and their respective agents with respect to all claims arising out of related to this agreement, any addendums or counteroffers. All claims arising from any purported representations of physical and environmental condition of the property covered by this agreement are the marketability of title, and all claims arising from any special assessments and or utility bills which have been or may in the future be charged against the property covered by this agreement, and in addition agree to indemnify and hold harmless. It's CYA language, basically. Basically, they're hiring third-party people to take care of title issues, home inspection, whatever. We're not responsible for it. Lead-based paint disclosure inspection, we did have a note in here about prior to 1978 only, just to make it a little bit easier, but this is standard language as well. Land Division Act, we did leave a number. I want to talk a little bit about this because we put some clarification in here under Land Division Act. So when you're selling property, obviously you're deeding the land, but you're also conveying the right to make future divisions. So the grantor grants the grantee the right to make blank. And in parentheses, we have insert 0 or a specific number as appropriate, divisions under the Land Division Act. So this comes into play, and I know I've had individual conversations with most of you about this, but the reason you want to put a specific number in here or 0 comes into play really only if the seller is keeping some of the land, if they're only selling a portion of the holding that's adjacent. So if I own 40 acres and I'm selling 10 acres of it in this purchase agreement, I want to put a specific number in there. If I put all, so on a 40-acre piece of land, there's 4 splits for the first 10 and 1 split for each of the additional 10 acres. So there's actually 7 land divisions available on a 40. If I put all in this and I sell that 10 acres and I give them all, it doesn't mean all that's available on the 10. It's saying I have 7 splits on my 40. I'm giving all 7 of those to you if I put all in here. So you want to put a very specific number. If you want to allow them to split that 10-acre piece into maybe 2 parcels so their kids can each have 1, or 3 parcels or whatever it is, you want to put a specific number in there. If they're just selling a house in a neighborhood and you want to put all because you don't really know how many splits, the reality is there probably aren't any in that case, but you could put all in that scenario because they're selling their entire holding. There's no adjacent lands that they own, so it wouldn't negatively impact that. And then we have a, this is, next language is required to be in there, but we also put caution. This is from one of the contracts that we had. If the space contained in subparagraph A above is left blank, the deed will not grant buyer the right to any divisions. A transfer of all divisions may be taken to include a transfer of divisions from continuous parcels. So just kind of a reminder to people when you're filling this out, to be specific if you can. If it's a piece of property, a larger piece of property, you don't know how many splits there are or whatever, you may have to contact the assessor and say, okay, did they give away any grants, any land division with other properties, or there's a lot of rules involved with Land Division Act. But whenever possible, you want to put a number in there. If they're selling the entire holding, it's not as important. You can put all in there if you want. Has everybody got a good handle on that? Sounds good. Property.
So it says for unplatted land only, so if it's platted land, then.
Well, if it's a subdivision or something like that, it doesn't. I guess it should have been more specific. If it's a smaller piece of, India chiming in on brokerage books. Yeah, if it's a platted subdivision or something like that, obviously it doesn't apply, or site condo wouldn't apply. But if it's a small piece of land, they're selling their entire holding.
Yeah.
Property inspection. Buyers personally inspected the property and accepted it as is. Present condition agrees that there are no additional written or oral understandings except as otherwise provided in this agreement. We do get some confusion sometimes with as is language. People are like, well, can I still do an inspection? Yes. In this portion, you're just agreeing that when you take possession of the property, you've done all your inspection, you're agreeing to take it as is at the time of possession. Not that you're agreeing right now to take it or leave it. And again, this is pretty specific language in terms of how inspections are handled. So I want to read through each of these items too. Offer is contingent upon satisfactory inspections of the property at buyer's expense, not later than blank business days of the date of this agreement. These inspections, and again, that's business days. We put a clarification point in there because a lot of them just said days, and it wasn't clear. These inspections may include, but may not be limited to, structural and mechanical inspections, survey and site investigations, soil borings, as well as inspections for radon, pests, mold, and/or asbestos. Buyer agrees to return the property to its prior condition after any inspections or tests. Buyer is not satisfied with the results of any inspection upon written notice from buyer to seller within this period. This agreement shall terminate and any deposit shall be refunded to buyer. That's an important line in there. A lot of the contracts, the TAR forms for the longest time had substantial impact was that kind of threshold, that if something's found to be a substantial impact, then you can renegotiate or get yourself out of the contract. And what it turns out being is that that's so ambiguous that it's a get out of jail free card anyway, basically. So more of the newer contracts are using this type of language where basically it is. If you find stuff in the inspection where you're just not comfortable with the home, you can get out of it so long as it's during that inspection period. In the event that the buyer neither removes the contingencies nor terminates this agreement in the time provided, buyer shall be deemed to have waived this contingency. That's important as well because in TAR, it didn't really say, it said you had to do your inspections within that period, but there was a specific language that said you also need to request a termination of this during that time period. Basically said do your inspections here, but somebody could technically come back 5 days later and say, yeah, we did our inspections then, but we're not happy with it, so now we want out. So this language is much more specific that they not only have to do their inspections, but they have to ask for any concession or terminate this clause during the inspection period. This is not, yep, go ahead.
What about well, water, and septic if it's required and who pays for it?
We have that below here under point of sale.
Okay. Let's see. And the seller, otherwise.
Yes.
And the upper. Okay, thank you.
You're welcome. Let's see here.
Ed, I have a question.
Sure.
I make all of my buyers sign an inspection contingency release, even once it's past that time frame. Do I have to do that, or can this cover me to where I don't need to try to track all those down all the time?
That's more a matter of practice. Some brokers require that their agents have a release of contingencies. I think this language is tight enough where as a broker, I'd say you don't have to have that, Kimberly. It's up to you if you want to. But one of the reasons I like this language to be this specific is that I think it covers us, even if that's not in place. But you still may have transactions where the other broker is going to ask you for that and require it of you. So again, more of a matter of practice for brokers than anything else. It's not a legal requirement that that's signed.
Okay, yeah, because I would get a lot of flack from some of them saying, well, we're already past the inspection time, so you don't need it, and they wouldn't want to get it signed for me, but I always used to do it as a protection for my sellers.
Yeah.
But I don't need to then?
I'm not going to require it as the broker. It's up to you if you feel that you'd like to do it as a matter of your own practice, but I think this covers it. So in terms of where we're at, I don't think it's necessary.
Okay, thanks.
Yep. Another interesting thing here, this language, any request by buyer to modify this agreement based on the results of an inspection shall terminate this agreement unless A, the request is agreed to by seller in writing, or B, the buyer removes the inspection contingency in writing within the time for inspections. So basically what that says, if a buyer comes back and says, I want $5,000 off of this deal because of a bad roof, and my seller says no, then it's going to terminate the agreement. Or the buyer can remove that inspection contingency, but they've got to do it within the time frame for the inspection. So that's kind of tough language, but I think it's very specific, and I think it causes that buyer to really work within the time frames that they're given. I think too often buyers don't take their inspection contingency seriously. This isn't language that we made up. This is, I believe, from Mar. Kelly would know that, and I'm sorry, but I don't know if I'm seeing Kelly's chats in here. But Kelly, if anybody else sees a chat in there, Kelly, when we went through this, I believe that's right from the Mar language. If I'm wrong, you can correct me, Kelly, and I'll let them know where it stands. Let's see here. I think with the screen share, there you go. Yes, Mar, Kelly says. Okay. Okay, any questions on all of that?
So you're saying that basically they have to come to terms or release the contingency within that?
Unless the seller agrees to something else. So if somebody submits a $5,000 request, the seller can keep the contract going if they want.
Yeah,
but the buyer needs to understand that by asking for a $5,000 concession, you are possibly, if the seller says no, then you're going to have to withdraw that during the time frame. So.
Or, yeah.
Or what?
Yeah. or the seller would accept it. You know what I mean? Typically how it goes, the seller comes back and says, okay, we'll accept this or whatever it is.
Beyond that, that period of time.
Yeah. It gives the option for the seller to
Yeah.
negotiate that out. Let's see here. Sean mentioned point of sale. So this is another one where a lot of townships do it differently than different counties, and there's probably going to be some state stuff coming up. There's dune protection laws in some federal areas that are kind of crazy. I don't know if any of them are requiring point of sale on that, but there's all kinds of point of sale inspections that are being required now by local, state, and federal agencies. So to come up with just one concise thing that basically says seller's responsible for that. Anything that's a point of sale, and that's typically how most of them are written. So in Kalkaska County or in Benzie County, it's required as a point of sale, but it's not necessarily required that the seller pays for it. So that's become the matter of practice. That's what we're going to say. If you want to change that so that the buyer pays for it or something, you can do that in the additional conditions. But this is just to clarify.
Should there be a time period on that? If this was my buyer, I would be really upset with the seller if they waited for 2 days before closing and they suddenly found out the septic was bad, and the buyer, paid for an appraisal, paid for everything else.
Yeah.
I think there should be a 10-day time period on that as well as the home inspection, because not knowing that, and sellers, they'll wait till the last minute. But if it was my buyer, I would want to know within 10 days before I paid for an appraisal, before I paid for everything else. And I think it would be in the seller's interest to have it done within 10 days. There's no time period on that point of sale.
Yeah, I can see that. And one of the hard things becomes some of them are county required, which can take quite a bit longer. Some of them with a private individual.
We could at least say that the seller must order it within a certain time frame. Because Cecil Dunn waited, I found out later, till after the appraisal was
Maybe
done
that's on the
to
list.
order the point of sale.
Yeah. Well, it wouldn't be on everybody's listing agreement. You know what I mean? In terms of their responsibility on point of sale. It is a problem. I do like that idea of putting a time frame for which they have to order it within 7 days of the effective date or something like that. Because again, Sean, I think the tough thing about saying within 10 days you've got to have it is you're relying on third parties to get it done in 10 days. You know what I mean? The health department or a contractor.
Kalkaska County guarantees 2 weeks.
They're giving 3, and you know, in 7 days to order that.
To order it, yes.
Well, sometimes.
Because it sits at the health department for 2 weeks before it's approved.
Or you have to go out and flag the property.
Still ordered it.
Right.
Yeah, you order it.
But at least they know it's coming, and at least they didn't wait till 3 days prior to closing to order it and push back the closing. But some type of a time period needs to be on there, I believe.
Okay.
I agree.
One thing I just ran into in Benzie County, usually I'll order it when we get the accepted offer. In Benzie, the evaluation is good for 3 years, but the water is only good for 6 months.
Yeah.
And
Right.
I know some of them you can't really do it when you list the property.
No, and I wouldn't want to do it when I list the property either, because if they don't get an offer for a year or so, and then they pay $450, and that's just money down the drain. So it can get a little dicey.
Yeah, but I think in the buy sell, to say, okay, here's our deal. If we put it together, you gotta go make application for that within 7 days or 10 days or whatever it is.
I'd say 7.
Does everybody think 7 is a reasonable number?
Yeah.
Because again, like with some septic inspection, you're gonna have to go to the site, you're gonna have to flag the property, you're gonna have to, should be able to get that done within a week.
Yeah, in the summer sometimes it can be up to a month, depending on how busy they are. Yeah. Yeah. I always do it as soon as I get the accepted offer.
I tell my sellers to do that as well. The minute we're under contract, you're looking at it going, this.
I just fill out the paperwork and have them sign it, and I deliver it to the.
I don't know.
Okay, well, let's go ahead and go with 7. I saw Kelly chimed in with, let's nail down specifics tomorrow, but she's noted that change. So we will add a certain number of days, I think 7 for now, unless everybody feels strongly after the fact to shoot me an email or something. But for now,
7 to apply. Or
7 to apply.
Yeah.
Yep.
What happens in the event that somebody goes to all the expense of doing these inspections And then your buyer just walks away for something stupid on the inspection, like
That's
with
the
the
tough-
house. Then you-
Sellers in my county have a 2-year shelf life for that inspection.
Yeah, but like Vince says, there's a 6-month on a water test.
So you can get another water test.
I mean,
Depends
I
on
can
the lender.
They're not that expensive.
maybe, maybe we should make it so that it needs to be applied for within a certain number of days of removal of inspection contingency by the buyer.
Yeah, because there's so many buyers that'll walk away for something stupid because they get buyer's remorse or whatever, and then you've got a seller that's had all that expense for
Yeah.
just some wishy-washy buyer. So those septic inspections can get pretty costly in some counties.
What about within 5 days of removal of buyer's inspection contingency?
Then you're still running into the possible appraisal period too.
The buyer splits it. And then the top to it.
Yeah, I mean, that is just, again, I don't know that, I mean, I understand what you're trying to do with the change, and I think on the surface of changing it to 7 or 10 days makes sense, but from our seller's angle, that does make it difficult. And unfortunately, I think this might be one of those ones where I don't know how you cover it by contract. It's one of those things where the realtors involved just have to get on their clients to do their part, you know? And I have had deals, I've had a couple where I dropped the ball, frankly. I was like, oh crap, that's Kalkaska County and I didn't do the septic. And then you call your buddies over at Milliken and say, please get out there. So it is a problem, but again, I don't know how we address it, because I do think that if you go just 7 or 10 days from the effective date, then you're putting the seller in a position where they are possibly taking on expenses that may not go toward the closing of this transaction. They may have to do it again down the road.
That's the way I've always done it. And a lot of times the home inspectors up here, they will do the well and water test for you. And if it's one of the home inspectors that does that, the seller pays the home inspector while they're there to do it. And that way I don't have
Yeah, but some counties are, like Benzie County's, it's health department. You can't get it from a private contractor.
Yeah, and the way it used to be worded on the Grauer ones, the health department or a qualified inspector. So
And it had a specific time frame in there when they had to order it?
10 days.
What if you guys just had a special addendum? Because I don't run into it as much as what you guys would, but what if you had just a special addendum for the agents that deal with this a lot, and you just have a spot on somewhere where you say, see attached addendum on septic and well, and then you just shorten the inspection time frame to, 5 or 7 days because of having to have that within 5 days of the release. Something, to where agents are going to have to be on top of it, of course, if you know that it's going to be a situation where you might have a lengthy inspection period for that, you just shorten their time frame on inspection for the house so that you're past that.
What if we can change it to be a certain number of days prior to the closing date?
There you go.
Well, the appraisal could be done. The appraiser is normally out there in about 2 weeks, and I'd like to have it, if it was my buyer, I'd want it done before the appraiser was out there. If it was my seller, I'd want it done after the appraiser was out there, so that.
Well, I know, I think that's wherein lies the problem, is that it's not, and in this case, I guess we're writing these on behalf of our buyer, but we may be double dipping too, and so you
Right.
got to take your seller into account as
Don't
well.
cover point of sale on septic inspection or a listing agreement? Haven't we already told the sellers that they're going to be?
Yeah, but if you're bringing a offer on somebody else's listing, that's,
Well,
you don't know what their listing contracts include. All right, you have 24 hours to send me an individual email with your thoughts on this one, everybody, and then I'll work with Kelly tomorrow and we'll figure out how it's going to end up, okay?
I think in the end, it's expensive, but they can use it for the next.
So
year.
shelf
Most of the time they can.
It's not
We ought to be able to find something that works,
in
so.
this market, it's probably going to sell. When we
Yeah.
were doing 2010, 2011,
Yeah.
I had some sellers who did have it done because we were going into the winter and they wanted it sold, but
Yeah.
it still didn't sell. In fact, it didn't sell for 7, 8 years.
Yeah.
So they did it again, but
Yeah.
That was a risk.
Well, let's, again, I think I agree, Sean, that the way it's written gives too much opportunity for the seller to drag their feet and end up delaying the closing. So again, why does everybody send thoughts? If you've got specific thoughts on it, what language might work, send them our way, and then I'll work with Kelly tomorrow to figure out some final language. But we'll put something in there that prevents the buyer or the seller from being able to drag their feet and possibly delay the closing.
I've had them do them within the 10 days, and then something happened with the home inspection or the appraisal was bad, and I'll actually have that well, water, and septic report as an attached document on the listing, and it makes the next closing go a lot faster, and they're good for at least 6 months.
Yeah.
So I put it on the actual listing before, and it makes the next closing go a lot quicker.
Okay. Yeah, and sometimes we beat these things up so bad, there's going to be very few circumstances where it comes into play. So if you do have one where they did a water test and it's only good for 6 months, another buyer comes along 8 months from now, maybe you just provide them the previous water test and say, hey, this was done. Well, they have to have another one though. Yeah, they may just have to.
Not a cash buyer, they don't care. That's good enough for them usually. But for mortgage, some mortgage companies specifically, it has to be within 6 months. Some of them a year. They're all different.
Okay. Well, we'll revisit that. So again, if you got strong feelings about it, shoot me an email with what you'd like it to read, and we'll take that input into account, and then we'll come up with something that addresses it, okay? All right. Earnest money deposit, buyer deposits, blah, 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 to be held by blah, blah, blah. So this, we wanted to get very specific on this language as well, because a lot of the contracts that were being used were not specific in what has to happen to that deposit and how it can be released. So I'll read through this if you haven't already. If this offer is not accepted or title is not marketable or insurable, or if the terms of the purchase are contingent upon ability to obtain a new mortgage or any other contingencies as specified which cannot be met, the deposit shall be refunded to buyer. Basically, if there's a contingency in this contract that does not get met, that is going to be refunded to the buyer. In the event that the buyer and the seller both claim the earnest money deposit, the earnest money deposit shall remain in the escrowee's trust account until a court action has determined to whom the deposit must be paid, or until the buyer and seller have agreed in writing to the disposition of the deposit. So that's how we handle it now. Some contracts were clear in it, some weren't. We pulled this, I think this is MAR again, to be very specific that the only way we're releasing that escrow deposit is if we have agreement between the buyer and seller. If we can't get agreement to buyer and seller, I'll turn it over to the court, and they can be the interpleader for it. The court will decide who gets it. And that's how we've always handled it. This just clarifies. So any questions on that? All right. Let's see here. Default is very standard language. Limitation. This is a limitation of 6 months on legal action arising out of the contract. Attorney's fees. The loser pays the winner's attorney's fees. This is the entire agreement. Verbal understandings and any other representation made outside of this do not count. Talks about the information on the sale having to go in the MLS. Agency confirmation. Walkthrough. This is an interesting thing that wasn't in some of our contracts, but I think it's important. Buyer has the right to walk through the property within 48 hours prior to closing. Now that has to be agreed to between buyer and seller like it always does, but we wanted to put that walkthrough language in there. Arbitration, this is real standard. This is from Michigan Association of Realtors. We're defaulting to that, and really MAR is the one who provides arbitration. The local associations are responsible for carrying it out, but it's under a MAR rule basically that they have to provide arbitration services. If there's an attorney in the room, they would tell their seller or buyer not to initial this area, that they want full legal recourse. My attorney tells me the same thing on this, that I shouldn't initial these areas because it limits me in what can be done. Non-binding arbitration, but still things are said during those arbitration hearings that are recorded and that are now public record, that not public record, but that are now on the record that were said. So if legal action were to arise subsequent to that, that could damage your case. So any attorney would say you want full legal recourse. don't initial on these arbitration things. When we're setting up the automated signing for these on DocuSign, these are not required fields. So your seller or buyer can choose to initial these, they can choose not to. I do not want us to initial these here, but this language has to be in our contract. So it's legally required to be in there. It's not legally required that the parties initial and say we want to arbitrate. I don't want to arbitrate, so don't initial on our behalf on these ones. Any questions on that?
It doesn't necessarily take away their right to arbitrate, correct?
No, you can still agree
There, and that's what
outside
I
of this to
thought.
go to arbitration if you want to. But by signing this, you're basically saying, I agree to go to arbitration before taking any other legal action, and that's what we don't want. So this is in there because it has to be, but I don't want us initialing that we're going to agree to arbitration. And whenever I talk to my clients on these contracts, I say just that. You know, I've been in the room when attorneys have filled these out with their clients. Seek legal advice if you like, but every attorney that has been in the room has said, don't agree to this. You want full legal recourse. So I kind of put it back on their attorney. Get legal advice if you'd like on this one.
Because we've come up with our own company agreement, do we anticipate any pushback from other companies, maybe if we're representing the buyer or the seller, if they see this, are we anticipating any pushback?
Having a unique contract?
Yeah.
I don't think so. You're seeing it more and more, and it's because the general forms that MAR puts out or that the other companies put out are kind of the bare minimum. They're providing it kind of as a service to their members, but it doesn't take into account enough, I think, local situations or, specific legal situations. So I think you're seeing more and more people developing their own contracts. Not necessarily in the smaller boards. I think like a lot of other things, a lot of the smaller companies, well, sometimes they're even worse. Actually, there's some local brokers who are really old school, they want to pay you the commission rather than have the title company pay the commission and stuff. So I don't know. I don't think so, but I would definitely, say to them, listen, these are our own contracts. That's why we put our logo at the top to make clear that this is not a MAR form. This is not, read it, and you guys should be in the practice of that too. Whenever you get a contract, you may think you're familiar with it, but it's up to you to read through it and make sure your clients understand that contract. And so if you get a contract in, even if you think you know what it says, they change all the time. There's a lot of different versions of the TAR contracts floating around out there, and they've changed the terms over time. So we need to be reading every contract word for word.
Schmidt for the first time, especially, I read that mostly.
Yeah. So I think it's becoming more and more common, and if they have a problem, I mean, again, people can use any contract they want. Their attorney could give them a different purchase agreement that they want to use and want to submit. And we kind of have to go along with that. If we can get our realtor language in there, it's important. But these are just kind of suggested contracts. All these contracts that everybody uses. This is the one that, as the broker, is the one taking on all the liability and who named on all the legal lawsuits and stuff. This is why we want to use it within our company because I've got confidence in it.
Is there any way we can find out what other companies are charging, the buyers and sellers?
Oh, there's a $150 fee is very small by today's standards. I think Northland's $360, $495.
For Schmidt was $360.
Yeah, $150 is very, very small.
Yeah.
And
of course nobody else did, but I've done it for the full past year. I have not had anybody. A couple times people are like, well, that's what I'm paying you the commission for. Well, not really. This takes care of all the electronic documents that we're required now to do.
And your broker requires it. I mean, we're the bad guy in the thing, really, if you want to put it that way. Listen, this is a fee that my broker charges, and then they put it to good use.
In my head, depending on the client, depending on the situation, I'm always prepared to say, you know what, I'll take care of that.
And that's the thing. We know
I
going
have not had to do it.
Yeah.
But I'm always willing to do it to save the deal.
And if you get that one client who's just, to their core opposed to fee structures, and you're not going to get the business, or they, don't cost yourself a deal because of this. I think that 95% of people we deal with are going to understand and not have a problem with it at all. And on those 5% of people who are just adamantly opposed, like anything else, don't don't let it cost you the deal. And if we, as a broker, eat some of these things, I also don't want you guys eating a bunch of these. You know, it's not intended to be a fee to you. It's a reasonable fee. It's there's a reason that so many brokers are charging fees now, and it's just because of the economics of real estate brokerages and how it works. And if you want to be able to do things over and above just allowing your agents to be MLS members and give them a spot, then you got to generate some more revenue, you know. And so, again, on those few people, don't let it cost you a deal. And if you have one, just reach out to me. Hey, I've signed this deal. My buyer refuses to pay the fee. Here's why, or whatever. And, you know, we'll probably just go ahead and eat it.
No, I had seen on Century 21 a while back, like 450 or something.
Yeah. There's.
Yeah, so use that to your advantage when they're questioning it.
Well, that's why I was just curious
Yeah,
if we do.
360.
Yeah.
Maybe it's good just to make a mental note.
Well, I think you can't discuss that.
No, but
Just
it's
like you
just
can't
nice to
discuss
know.
commission rates versus other
Right.
brokers.
Right.
But you certainly can say, you know,
It's
the
becoming
fee we're
more
charging, I mean, it
industry
was
norm.
tempting. I got to say, when we were looking at doing a fee, pretty tempting to say, okay, let's say $300 on every one. That's pretty cool. But what we actually did was look at the money that we were spending already and the money we want to spend on resources for you guys, like DocuSign, like brokerage books, which you'll see a bunch of changes. Actually, they're full-time in brokerage books now because we've instituted this fee. And it's going to allow you guys to be a lot more efficient. So I think when we looked at it, we didn't look at it as just a money grab. We looked at it and said, okay, what do we really need to generate in order to do what we want to do for you guys? And we settled at that $150 fee based on how many deals we close in a given year. So certainly not a money grab, you know. Okay, electronic communication is very standard language, allowing us to email documents and use digital signature software. We actually did add that. It was interesting. Most of the contracts did not have language for electronic signature software. It said email that you can use or whatever. Yeah. So we did want to make sure that, you know, electronic signatures were something that we could be doing legally as part of these contracts. Heirs, successors, and assigns. It is worth noting that the buyer should not assign this agreement without seller's prior written permission. So these contracts are not assignable unless the seller agrees to it.
Right.
I can't say I'm the buyer and then go
As
sell
the
my
wife.
interest to it and say, oh, by the way, Betty Smith is now the buyer. The seller has to agree to it, and I think that's how it should be. The seller looks at your financial setting, they look at you, and, you know, decides to move forward with you. So 33 is important. Make sure an attorney reviews anything if they have any questions, and then other conditions area. I do think that how the counteroffer work is worth looking at because it is a little different. Some contracts, MAR contract is what we're using, have it where if I sign as the buyer, here's my offer, and then it comes to seller's acceptance. There are contracts that have a seller counteroffer clause in here, not a seller's acceptance clause. But with this format, basically it says the offer is hereby accepted either as written or with the following changes. So if you're accepting it as written, you check as written. If you're countering price or other terms, you select with the following changes, and you change price or whatever you're changing, and then it gives the buyer an opportunity down here to accept the changes that were made. Obviously, if you go to that next level where the counter to a counter, you're going to end up with addendums, and that's just kind of part of the nature of it. So, any questions on anything else? We're going to look at, I think the only note we came out of on a possible change or probable change is that point of sale. Yeah. Everybody okay with all that? All right, let's go through the listing agreement real quick. And again, Kelly chimed in, for the most part, it's just MAR contract. If you look at the MAR contract next to the one we did, I think there's 4 areas where we made a language change, maybe 5 areas we made a language change from the MAR contract. And the vacant buy and sell, we won't go through that right now. You can go through it on your own. Basically, we took the MAR vacant buy and sell and changed the exact same clauses we changed in residential. We just, you know, got rid of those that don't apply to unimproved properties. Okay. And by the way, fillable PDF, just like anything else, you click on the field and fill it in. So when you're completing these, you can do them just like you always have, where you fill it out here, save it as, and then load it into DocuSign. Or we'll show you how through templates you can go right into DocuSign to complete the contract and everything. And we're curious on the DocuSign thing. We got to play around with that a little bit more maybe. But it should be working well. But if you have any problems with that, let us know, because there may be some tweaking. We just haven't seen that in practice yet. So if there's goofiness there, we'll have to go over it. But okay, so contract, basically the dates of it, our address, your name, email, phone, all this stuff is pretty standard up top. Market, sell the properties, find a buyer, seller gives homeowners LLC exclusive right to offer for sale and sell the property. Again, this is coming from MAR contracts, basically. I'm going to just go through. These are all very standard. Year built, we're not looking for, I know there was some conversation going along on a specific year built, 1958, 1942, whatever it was. One of the difficult things is that I don't trust the seller to really know that information a lot of times. They may have an idea from the previous seller or some documentation they have, but especially when you get into homes that are 30s, 40s, 50s, or earlier, who knows? I mean, you may have been told it was built in the 50s, and it may not have been at all. So I don't want to put our sellers in a position where they're saying in a legal contract that could be subpoenaed, my house was built in 1958, you know. They may not know that. So the key for most of this is 1978, and that's because of the lead-based paint. Let's see here, price and terms. We did put in here the ability to select what type of financing that they would accept. And I think that might have been off the recommendation from the Garrar forms, if I remember, that we brought in on that one. Again, we wanted to reiterate what appliances are included in the sale, so that when it comes time for an offer to come in, they understand what they're offering, and we can make sure that this matches up with what a buyer's asking for. 6 months, we just went ahead and put 6 months automatically in here. If after 6 months of expiration of the contract, the seller sells, trades, or exchanges the property to anyone that we introduce them to, we're still owed the commission. Seller agrees to pay. This was interesting. I think you brought this up, Kimberly, that maybe we need to move this admin fee up to before further. I think when Kimberly read this, she thought maybe that $150 admin fee was only going to be charged if after the expiration of the contract. And I hadn't read it that way before, but I think when I look at it here,
Yeah.
you could see that, okay, this $150 fee might only come into play if after the 6 month period. So Kelly, if you're still out there, that's a note we probably need to make, is to possibly move that up before further, so that it's clear that that's not a fee that's only charged if you're sick beyond the expiration of the contract. Let's see here. This is all very, very standard. Homeowners indicate acceptance initially. This is, again, how we went with, and again, I think this is from MAR, that we're going to offer to sub-agents, to buyer's agents, whatever we're going to do. You know, I kind of leave this up to you guys. I was going to change this all to where we're only offering it to buyer's agent, but in certain areas, it's just a standard of practice in that area that you have to offer to a sub-agent. Some people come in as a sub-agent of the seller. So I left it in there. When I fill these out for my clients, I'm going to check no for sub-agent. And unless you're in an area where you know that's going to cause grief, we should only be offering compensation to a buyer, somebody coming in as a buyer's agent, not as a sub-agent, and not as a transaction coordinator. So really, we should only be checking yes on buyer's agent on this one. Okay? But again, we left the other choices in there in case you're in an area where the standard of practice locally is that you got some agents coming in as sub-agents, or maybe you come in as a transaction coordinator, because we do have some of those throughout our service areas.
Well, the only time I would consider paying a sub-agent would be if you were to sell one of my properties. Because would you not be a seller's agent as well if you had a buyer?
Well, oddly enough, the broker is considered a separate. Homewaters LLC would be, but I, as an agent under my license, could come in as a buyer's agent, which is a kind of tricky place for me to be.
Yeah.
Because the broker's a dual agent, but I'm not.
Yeah.
So yes, I could do that, but that's a pretty specific scenario. All right, assessments. This is where we mention assessments in the listing. Seller acknowledges that the following assessments, fees, and/or dues remain outstanding and must be paid in full prior to closing or reach mutually agreeable arrangement for their payment with the future purchaser. I like this in there. It's not in our current listing agreement, I don't believe. I think it might have a yes or no that there are assessments. I want to know what they are when I'm listing this property. If you know there's a 10-year fee, $200 a year for the next 10 years, I want to know about that when I'm listing the property. So we're asking them for that information at the time of the listing. Let's see here. Showings and signs. Again, this is all very, very standard. We do have lockbox authorization, but they agree to release us, hold us harmless from any problems that might arise out of that. This is important, referral language. Seller agrees to refer to Homewaters LLC all inquiries received concerning the property during the period of this agreement. I do not want our sellers out there trying to put their own deal together and go around us. They're agreeing when they sign the listing with us that if there's a lead on it, they send it directly to us. If they don't, they're in breach of the contract. Possession is standard. Citizenship has to be in there. Heirs is standard. No discrimination. This is standard language in there. I like this conflict of interest. Basically, it states that, well, I'll read it. Seller understands and agrees that as a part of marketing the property, Homewaters LLC will show potential buyers properties other than the seller's property and provide such buyers with information on the selling prices in the area. Seller also understands and agrees that Homewaters LLC can show seller's property to and obtain offers from all prospective buyers, including buyers with whom Homewaters LLC has an agency relationship. In the event a buyer with Homewaters LLC has an agency relationship, shall become interested in the property, Homewaters LLC shall notify both buyer and seller. Homewaters LLC shall act as a mutually agreed upon disclosed dual agent of both seller and buyer. Homewaters LLC shall be entitled to the total compensation provided herein. So a couple of different things. They understand that while yes, it's our job to sell their property, we also may be representing other properties that we have to sell, and there may be a buyer looking at more than one of those. So if our buyer chooses to buy somebody else's property we have listed, it's not that we didn't want to sell your house or that we did anything to negatively impact the possible sale of your house. That's just how it worked out. It's a better fit for them. And then dual agency. So if you do end up in a dual agency situation, in the blank contract documents, there's a disclosed dual agency form that all parties must sign that says everybody understands I'm a dual agent. Okay, that kicks in if you end up in a scenario like that. And then finally, we get the total compensation. So unless you've agreed to somewhere else in this contract, you take both sides, you get both sides. Now, most of mine, I write in that I'm going to give up 1% if I take both sides, but I have a different commission structure than you guys. You can choose to do that or not. Oftentimes I use that if I'm trying to get 7% commission on a transaction. I'll say, listen, let's settle it. If I sell it, I'll do 6, but only if you're listing at 7% with me. I'm not automatically taking that cut. If you want me to list at 5 on a property at $250,000, I'm probably not taking the listing, but if I do, I'm certainly not discount if I take both sides. So the default in our contracts is that you can take both sides of it. If you want to change that, you'll have to make it a separate note in other that you agree to reduce the fee by 1% if you take both sides or whatever it is. I don't know. You guys know how I feel on commissions. We work hard. We earn them. And we shouldn't feel bad about that. We provide a service that they can't get somewhere else. We're going to help them sell their property for more. We're going to earn our commission on it. So that's always my take. If I have to do it to get a very important listing or trying to break into a new area, maybe. But otherwise, don't give away your commission. Okay, let's see here. Exceptions. This is another thing that we put in here that's pretty specific. So we wanted you to have something in here where it kind of starts a conversation. So should one of the following named parties execute a purchase agreement and with terms agreeable to seller within X days of this listing agreement? Homewaters LLC agrees to act as a transaction coordinator, fee of blank or percentage of sales price. The expected parties include. So this is a lot more specific than what we had in especially the TAR agreements, but most agreements. And the reason we did this is that whenever we've had a seller who says, well, my neighbor Joe has said he wants to buy the property, so I want him to be an exclusion to the contract. Well, okay, I'll do it as an exclusion, but I'm going to limit the time frame. If I'm 30 days or 60 days into this, now I've got some time involved. There's probably other parties involved, and it's just too late for Joe, your neighbor, to get involved. So within 30 days of this listing agreement, if Joe comes forward and puts a deal together, fine, I'll accept him. But if you'd like, I can still do the contract. I can still do the paperwork for you for 1% of the sale, or I can do it for $1,500 or whatever it is. I want to give you guys the opportunity to not get totally cut out if the exception has to come forward. So that's why this language is probably a lot more specific than you've seen in other listing contracts that you've used. Any questions on that clause? Okay. Hold harmless clause basically for us. So hereby acknowledges homeowners LLC is relying on representations, oral or written, made by the seller. This is standard language. I do like this too. This is where you get the opportunity to talk to your seller about this land division stuff. If they have a larger holding and they're only showing a portion of it, selling a portion of it, you'll want to have that conversation with them here. If they own a subdivision lot, if they own just a 5-acre piece and they're selling the entire 5-acre piece, it's not as important, but this is the time to have the conversation with them so that when it comes up in the purchase agreement, it's not a surprise to them and they know what they're talking about. So this just kind of tees it up for you. Let's see here. This is also a pretty good one that gives you some more information about the listing. Make sure that the split's been approved that they're talking about selling, or if we still need to get split approval on it. Seller's disclosure language is typical. Limitation, again, on a lawsuit, they're limiting it to 6 months. Attorney's fees, the loser pays the winner. Same thing. This is all just kind of legalese. And this is interesting. Cancellation. This agreement can be canceled or revoked only by mutual consent in writing. So that is interesting because what we wanted you to do is if you have a seller, we usually just let them off the hook. I mean, rarely would you hold somebody's feet to the fire. But what I want to do is make sure that if, unfortunately, there were a number of transactions this year where they just kind of defaulted on their contract, basically, and we didn't have much enforceability. This holds them to the contract until we let them out under the terms we want to let them out under. You know, you want out of the listing agreement, you don't want to pay me a commission. Okay, I'll let you out of there, but I put in a lot of work and it's going to cost you $5,000 to get out of it or whatever. Very limited scenario that you would hold a seller accountable like that, but I wanted the ability to do that in case we run up against one of those folks that's just trying to kind of do a deal around us or get out of it for, you know, some reason along those lines. All right, that is the listing agreement. Any questions or comments? Everybody still awake? I'm going to keep on the screen share. Actually, you know what? I'm going to stop the share at this point because we're running over here and everybody's got stuff to do. So let's see here. So basically, those are the contracts. If you go into DocuSign, you will see in there, and I believe they're all in templates. One of the reasons I don't want to go through this now is because I haven't had a chance to run through this with Kelly and make sure that it's functioning as we want to. But when you go into DocuSign, there's an area off to the left that says templates. And if you choose to, you can play around with that. And what you would do is hit use one of those templates for the buy, sell, or and the way that it works is all the signatures. All right, I'm gonna do a screen share. Sorry, but I've got y'all here, so I'm gonna take advantage of that. All right, so if I go into DocuSign, I'll show you real quick, but we will do another training on this specifically because I have a feeling that we're going to need to tweak it a little bit, but I'll show you how we have it set up right now. And by the way, thank you, Kelly, if you're still out there. She is, yeah, this has been a process, and she's created all these fillable forms from scratch, hand typed in the entire thing, making each form fillable, either required or not required, and every time you make a 3-word change, it pushes everything down the page and you have to reset the initials. So thank you very much, Kelly. You've been awesome throughout the process, and I know we've got, looks like maybe 1 or 2 more changes coming up, so hang in there, but we should almost be done. So if I go to templates, I can go to, let's see, all templates, and you'll see some in here. Now this is one that I created. I'm going to actually delete this off of here. So here's the listing agreement template as an example, and I'll hit use. So Kelly has gone in and preloaded roles in here. So the seller agent would be me in this case. And then you just put in the name of your seller, which is Tom Jones. Tom, yeah. Let's see here. And one of the things I noticed, Kelly, if you're listening, is that right now we have a required that you have to enter seller 2. We want this to be optional. You'll see that the order is already set. It's going to go to me first, and then it's going to go to my sellers for signature. But what you do is you just put in the roles, and then I'm going to actually send this. Now it's only going to go to me first. Yeah. So this is one thing we need to change, is to make it so that you can select 2 sellers if you want, but you don't have to. And then I hit send. So again, it hasn't actually sent it to anybody but me, but when I get it, now I fill it out. So I fill in all the terms right here in DocuSign.
Is there a password to get in?
For DocuSign?
Yeah.
I'll go through it with you. Yeah, some of you maybe haven't used DocuSign before. Okay. So obviously you can use these contracts just like you've always used them. So if you're just comfortable with that, go ahead.
Yeah.
What we're trying to do is save you some steps. So what this does, again, I can fill in all the fields in the contract, and I sign it where it's required by me. My signature locations are already applied here, and all of the signature and initial locations for your sellers are already applied on this document. So once I finish it off and hit finish, it automatically sends it to my sellers, and all their stuff's already filled out for them to sign. Everything's already placed in here. So it more a time-saving unit for those of you who do use DocuSign. The purchase agreement's the same way. You open it up, you put in the names of the people who are a party of the transaction, you hit send. It's going to go to you first to fill out, and when you complete it, it'll then automatically go to your clients. So that, in a nutshell, is how that works. Again, we're playing with it still. So if you're somebody who really wants to use it that way, let me know, or give it a shot, do kind of a test run, and if you find errors, let me know. I'm kind of been waiting for the right opportunity to use it with a client that I know well, or that kind of willing to be a guinea pig. But it should be working well. Kelly, we want to make a note, though, about the multiple signature situation. Yeah. So, okay. I try to keep these things at about an hour. I know we've gone over that, so sorry about that, but hopefully everybody.
Chat's there.
Yeah, let's see here. Aw shucks from Kelly. It's my pleasure. I want them to be right. Got it. So thanks again, Kelly, and we'll work hopefully one more time on this tomorrow, and we'll be on to other things. All right, it's almost 10 o'clock in the new year. Everybody ready to go out and work again, shake off the cobwebs, and get back at it?
Those cobwebs?
I think that wraps up the meeting for today, unless anybody else has any other questions or comments.
See you in a couple weeks.
Yeah, looking forward to it. We're excited about the party, everybody. Happy New Year, and we'll catch up soon.
See you, everybody. Bye.